What is formal legal notice in a family law matter? In every legal matter before the court in a family law case, you must show that the other side has formal legal notice that this case is pending. What does that really mean? Well, it means you simply can't go down to the courthouse, file a lawsuit, eventually take an order to a judge, and say, "Here, judge, I want you to sign my order." It simply doesn't work that way. The opposing party in your case must know that this case is pending, and you must prove to the court that you've given the other side formal legal notice that this case even exists, be it a divorce, modification, enforcement action, or some sort of suit affecting parent-child relationship matter. In Texas, more often than not, we try to get notice done via one of two ways. Number one, a waiver of service, or number two, formal legal notice provided by a process server. As you may know, a waiver of service is a document provided to the opposing party that simply states, yes, I know about this case, no, I don't want to do what the other party does without my knowledge and consent. They'll require a handful of personal information to be presented to the court, be it their name, date of birth, contact information like an address or an email, and potentially waivers of initial disclosures that are typically provided to the court. If you don't believe a waiver of service is likely to be signed by the opposing party, we can always provide formal legal notice via a process server. When formal service is executed by a process server, the process server himself or herself will appear at the opposing party's job, school, or possibly even their home to provide them with the formal documentation to inform them that a formal legal case is pending. Once formal legal notice has run, be it an answer has been filed or the opposing party doesn't do anything for 20 days plus an additional Monday, well, at that time, you may have the ability to default the opposing party. In that instance, you actually can take up a formalized order to the court and ask the court to sign off as is because the opposing party, despite receiving legal notice, never filed into the case. On rare occasion, you may not actually know how to get in contact with your opposing party. Maybe they've moved, maybe they've blocked your calls, maybe they've taken off and you have no idea where to find them. In that instance, you can potentially ask the court to do what's called a cite by publication. In other words, you have the ability to ask the judge to provide formal legal notice through some sort of newspaper article, newspaper clipping, or something to be provided in writing to the world at large and check that box for formal legal notice. Regardless of the formal notice provided to the court, you must ensure to check that box prior to presenting your order to the court. If you don't, it's incredibly likely that the court won't sign off on your final order, be it a decree or a modification order or anything and everything in between. If you want to know more about waivers of service, feel free to click here to watch another video about service and how it may help your case moving forward. Thanks again for watching. If you have any questions, feel free to leave a comment down below. For more family content, please subscribe. Or you can check out our website at familytexas.com.